Dear students, so welcome back to property law, industrial property law, sorry, and that would be HOE 6065. And so we're looking at patent law and the various aspects that go into it. So I've spent a lot of time explaining or trying to explain the various provisions of the European Patent Convention with the help of examples. And well, now it's time to proceed. And of course, we have the lecture today, so I'll try to wrap up patent law today and then add some information about designs law for next week's lecture. And then already we have the exams coming soon. So I'll update you all with the information about that as well, because these will be open book exams, and so I'll clearly mark out what areas you need to study and what you need to leave out so that there's not much confusion. As you can see, there's a lot of stuff here in the Moodle lecture notes. So I'll mark out what you should be focusing more on. All right. And so where were we? We looked at different aspects of patent law, mainly from the patentability point of view. I have a lot more examples, but it doesn't make sense. It's just a 3 credit simple course. So we look at some more aspects. Now remember, this is a purely legal course. So we look at things from a law perspective. And one of the very important aspects is the right of priority. It's also in the lecture notes. And priority is of great importance because basically, you see what's happening here is earlier you could file a patent in the United Kingdom, and that's a English patent. You get a patent in England. You could file a patent in Germany, and that's it. It's a patent in Germany, highly territorial in nature. It didn't even matter whether it was a copy of the earlier English patent. It didn't matter because these different jurisdictions were not interlinked. So you could have a patent in the US and you could make a exact copy of that and try to get it patented in Spain, and nobody could really do much about this. Of course, I'm talking about 100 years ago. Yeah. So this really couldn't continue, and based on the Paris Convention for the protection of industrial property, there was this need to have a bit of a flexible system in place. So now, if you remember when we spoke about the conditions for patentability, there was also novelty and it has to be new. So now tell me, how is it possible if I file a patent application in the UK and then file it in Germany and then in Brazil and then in Japan and then in South Korea and then in Australia and then in Canada and then in the United States? How would I be able to do all of that at the same time? Suppose I file the patent application today in the United States and I file the patent application tomorrow for the exact same invention in Japan. You would then say, hey, this is not novel anymore because this has already been put into the system one day before somewhere else. So this caused a lot of friction, and this is all very theoretical, right? I mean, how do you manage this sort of a thing? And so what the different countries decided was that they would give you a 12-month grace period, and that's very important from a practitioner's point of view, from a patent attorney's point of view, when you're filing a patent application. So there are all these convention countries, almost all WIPO countries are in that. And what they would do is, so it's very straightforward. I filed the patent application today in Estonia, and well, the term of the patent is 20 years from the date of application of the patent. So my first application is in Estonia, and let's say next week I file it in Finland. I could backdate that application to today's date because I had originally filed it in Estonia today. Similarly, I could file the same application in Germany after 2 months, and I can backdate it to the original filing date in Estonia. And so, you just have to put in the application form that you're claiming priority, and this priority is on the basis of a previous filing. And it's for the same application, for the same invention, for the same applicants, same inventors, everything is the same. So you have this little legal fiction, and you get this 1 year, 12 month period in which time you have possibilities to apply in different jurisdictions. Now, this is very important, of course, even from a commercialization point of view, because it doesn't really help if you get a patent in 190 countries. What's the point? Very often in the European context, the traditional approach is to apply for a patent in the UK, not in the EU anymore, but still under the European Patent Convention. Then Germany, of course, France, Italy, maybe Amsterdam. So that would be Netherlands, maybe. All right, that's it. 5 or 6 countries at the most. There's no point in applying for a patent in Estonia, Latvia, Lithuania. What's the population? 1.2, 1.3, 2.2 million. There's no point in applying for a patent in Finland. Where does it take you? Population of what? 5 million, 6 million. Sweden, okay, maybe because it has an industrial base and things. But you see, we'll be talking a lot more about this today. But it's very expensive to file a patent application, and so everybody wants to cut costs. And if you're not going to be selling a certain product in certain countries, then what's the point of getting patent protection? So this right of priority basically helps to cover up all the loose ends, and you have to have a patent in your main markets. That's number one, because that's where you sell the most. That would be the United States, Western Europe, if you could pardon the use of such terminology in a geographical sense. All right, and then of course Japan, number 3 economy, China, number 2 economy. Then where are all the copycats? So you have to apply even there in those countries just to protect your invention, and then that's it. You don't have to apply in 192 countries. What's the point of applying in Burundi or anywhere else? So you have to be very focused on which countries you want to have patent protection in. And of course, this can also lead to some problems, but then we talk about blocks and regional patents, and we'll talk about that during the course of this lecture today. But anyways, priority is very important. This 12-month period is very, very important. If you go above this 12-month period, then you're in serious trouble. Even by one day, then your patent application gets messed up, because what you're applying for a patent today in Canada has already been applied for in France 1 year plus 1 day ago. Now it doesn't matter that it was you who had applied it and it was done through your lawyer and for the same invention and the same applicants. No, that's not relevant anymore. This is a legal fiction. You have a 12-month grace period. Within that 12-month period, you can file in 15 countries, 25 countries, and you can backdate your application to the original first country where you filed. That's it. Now, next is product patents versus process patents. These are very important, especially in the context of the value of the patent. Now, a product is something that is a chemical compound, for example. So you get a patent for that chemical compound, and that's wow. That's amazing. If you get that patent, these are very rare. Maybe 2 or 3 in a good month. Very rare. In pharmaceutical industry, if you can get such a patent for a brand new compound or invention that's never been done before as a product, then that's really amazing. But normally most patents tend to be process patents. That's more about how do you manufacture this particular product. So if you get a patent for XYZ, the product, wow, all right. Then there's no way that anybody can avoid infringing your patent, because no matter what they do, they're still going to end up with the product XYZ, and that's your exclusive monopoly product. So you are in a win-win situation. But if you have a process patent, then of course there are different ways to eat food. You could eat food with your right hand, with your left hand. You could eat food like this, with a fork, with your hands, whatever. So each of these is a different process of doing something. And so obviously, it's like that example I gave you of the manufacturing of alcohol. You can make it in different ways. There are different forms of doing it. There are different processes. You can take the straight road. You can take the curvy road. You can go via something else. You can do all sorts of processes. It's like you want to go to the university from Kabamaya, so you could take number 3 trolley bus. You could take number 11 bus. Yeah, you could take number what is that, 11, yeah, um, express bus. 36 was another bus. Yeah, so there are all these options. You can take a cab, you can go cycling, you can go walking, you can go by helicopter. Each of these is a process, and so you have to be very careful. The point here is, if I have a process for making water, and that is I combine hydrogen with oxygen and then I get water, H2O. That's one way of making it. But another way of making water could be, I take hydrochloric acid, HCl, and I take um, you know, nitrogen dioxide, and I use some particular process through which hydrogen, chlorine, nitrogen, oxygen gets separated, and then I mix hydrogen with oxygen, and now I get water. See, that's a process also. I have not used just hydrogen or oxygen as pure elements, but rather I have taken this from a different viewpoint. So all of these are, of course, highly technical from a chemistry point of view, but each of these could then be a process. Or another thing could be, I take heavy water, H2O2, yeah, so that's my source, and then I use electrolysis or whatever to break away one oxygen atom, and now H2O2 after certain processes gives me H2O, water. So heavy water gives me simple water. So you see, each of these is a process, and so it's very easy for somebody to circumvent your patent. I mean, you have a patent for this process. Well, if I go through this way and come here, then I have circumvented your process patent. Now, who is entitled to apply for and obtain a patent? Well, the law is very clear. It's natural and legal persons. And, well, of course, the inventor is the first owner always, but then under a contractual obligation or whatever, the applicant could be the subsequent owner or whatever. You see, so there are all these possibilities, just like we discussed under. No, we haven't spoken about this in the other thing, not in trademarks. So basically, it all depends on your employment contract. So let's say I am working for Tallinn University of Technology, TalTech. So whatever I do in my work time, yeah, in the laboratory or whatever, is then the property of the university, because I'm an employee, and that's my job to do work in the university premises. So whatever I do outside the university, at home, in the night, or whatever, whenever beyond working hours, then that's my own exclusive property. But whatever I do during office time, work time, using university resources, is then a university owned product. And so that's how this thing works. But it's very important over here to see the Dabus case. So I put up this in the patent case laws. So there are two of these Dabus case judgments from the European Patent Office. Very fascinating. Of course, they deal with artificial intelligence, and they always come back to the same question here. That's the issue. You see, all IP laws, trademarks, patents, whatever, are designed purely from, how would you say, a legal viewpoint, wherein the person, the human being, is the inventor. It's a natural or legal person, and of course, if you don't have a natural or legal person, then you have a problem, because then it is not something which can be patented. And the Dabus case is, of course, a very good example of this particular situation. All right, let's see what happened here. Internet down. So What else? Well, of course, you have to designate who is the inventor. This is very important. If you don't do it, then you can get in legal trouble. And in the United States, especially, this is a criminal offense if you don't label who is the inventor and stuff like that. So, well, what must be disclosed in a patent application? And you can see there's also some examples out over there of what are um, patentable inventions, and of course how the application form would look like. So it's very simple. Of course, there has to be a detailed description of how you carry out the invention, and this should be sufficient so that somebody who is skilled in the art would be able to read your application and make out that yes, this is workable. I've given you a lot of examples about how this goes in the past, and this plays a big role with novelty, and basically person skilled in the art is the key criteria that is important over here. And also it has to be sufficiently clear. So what is sufficiently clear? Well, I gave you some loophole examples. Yeah, when you're making distilling alcohol, and of course there are some of these possibilities, but nonetheless, you see, it all has to be put out. That's the whole patent bargain, the whole big legal bargain. You disclose all the information, you as in the inventor disclose all the information to society, and in return you get a monopoly for a limited period of time. Now, where can a patent application be filed? This is of course of great importance. You could apply in the national office, so like in Estonia, in the Estonian patent office, in Finland, in the Finnish patent office, in the US, in the United States patent and trademark office. So of course, there are these possibilities. But as I said, the problem here is that this is not a very suitable criteria, because it's very cumbersome, and of course, well, that's how it was done, but it added to a lot of costs, because if it's in Japanese patent office, it has to be maybe in the Japanese language. If it is in the German patent office, then maybe it has to be in a German language. If it is in the French patent office, maybe it has to be in the French language. And so already you can see this is not your simple Google Translate sort of stuff. This is a bit more complicated. This is highly technical information. And so the translator will have to be somebody who is, a scientist in that field, whether it's a tap or whether it's a pipeline, whether it's, a soft computer software with a technical function, whatever, all of these. You need to now have an expert who also speaks two languages, English and German, who can then translate into German. And as I explained to you earlier, what's the point of having 150 patents in 150 countries for the same invention? Doesn't get you anywhere. So this was taken to the next step, which would be regional patents. Yeah, so why not have a patent situation where you could apply in 4 or 5 countries in the same way? This in the European context didn't quite take off yet. There is a unitary patent scheme, but it got stuck. It was supposed to come in this year, but maybe next year. It's there on the agenda. It's just a bit of an issue. So this idea was that you are in the European Union, then all European Union countries, should have the same patent law and this one window application stage. So you apply in Estonia, and the whole process is streamlined. The laws are the same. So whatever decision is then taken by the Estonian patent office or a centralized patent office in the European Union would then be applicable to all 28 countries or 27 now. And so life would be really amazing. Yeah. And this is a very utopian idea, but very, very radical. And of course, it would have really revolutionized things. Another plan was, now different courts in different European Union countries have different styles of interpreting the same law, and this often causes problems. So maybe it should be somehow worked out that there is one court mechanism in the entire European Union. So they decided that yes, we would do that, and the courts would be in London and Paris and in Berlin or somewhere, I think. Yeah, so all looked very well. Then there are 27, 28 countries, and so it became quite problematic what language should be the patent application. And so they all decided that yes, let's do it in only three languages. Your patent application can be in one of three. It could be either in English or in French or in German. And now that's where the problem started. The Italians were like, what the hell, mamma mia, how can you not have it in Italian? So they were fighting for a long time, but they quietened down. On the other hand, there was the Spanish, and they were super upset. They said, Spanish is more widely spoken than even English. So what the hell? How can you say that Spanish language is not going to be given priority? And so the Spanish have still not agreed, and they walked out. And yeah, okay, well, happens. What to do? They still wanted to go ahead with this process in the European Union, and then Brexit happened, and now here you have a serious problem. Now English is not the official language of any country, as in like the primary official language. And so how can you have a foreign language, yeah, like English now as a predominant language, one of three, when European languages like Spanish and Italian of European member states are not counted? And then how can you have a European Union wide patent code system when Great Britain, GB, United Kingdom is not in the European Union anymore? Yeah, so you see, all of this got messed up with politics, and so this unfortunately hasn't taken off. But something that's been around for a very long time is the Patent Cooperation Treaty, and this has been quite a big success. This, and you see, we looked at the national stage, national level, Estonia, Finland, Spain, France, national levels. And then we looked at regional level, like the European Union as a region, and they would have their own patent, which is a regional patent. And then there is an international patent scheme. In a way, it's not, of course, an international patent. That would be a wrong thing to say. It's a Patent Cooperation Treaty, PCT application. So basically what it says is you can apply in Estonia, and you fill up the form, and in the form you say that you also want to apply in, I don't know, 30 other countries. Yeah. Finland, Sweden, Russia, France, Germany, USA, Canada, Japan, South Korea, India, Brazil, China, of course, South Africa, Argentina, put everywhere. All right. And now you can do that, but you don't have to apply in all these countries. You can just state in the application form that you file in Estonia that you would like to do that, and you get 30 months, sometimes 31 months. So be careful about this distinction. And so what happens now? Well, it's in the national phase, and so you have now applied for it. This patent application that you've applied will now go to the head office in Geneva, where they will conduct the search, and they will give a preliminary report, and then you can follow it up, and they will do some searches, international searches and things. I'll talk about this process. And once this is all done, then they say yes, maybe, or no. And if it's a yes or a maybe, then you can sort of work your way around it, and then you get a patent in Estonia, and the same documentation process is transparent, and it can now be used to get the patent in 40 countries which you have applied for in the original form, and you have 30 months to do all of that. Anyway, that's the PCT, and I will talk about this procedure that I've just outlined. It's in the notes as well, but basically what you're trying to do is trying to make a single window system. That's what entrepreneurs, business people, researchers, scientists like. Nobody wants to travel to 25 different countries and have 25 different problems and 25 different cultural situations. Everybody just wants to have one single place. You press the button, pay the money, and everything gets sorted out. Yeah. So what does the patent application look like? Well, of course, there should be an application, and there is this Article 78, which talks about request for grant, and then how do you describe the invention. So there's the rules from the European Patent Convention rules. Then there are claims, drawings, abstract, and basically what we are looking at is a very simple process when you're applying. So what you have is you have the title, then you have an abstract which basically outlines what the issue is. Then you have a mini description in which you are saying that this is the invention, and of course there are these aspects to it. This is some of the issue that arises in the past. So this is how you could do something, but it was not perfect, it had some problems. And now you go to the next level where you describe what you have made and how you have made it better and what has been done to distinguish it from previous inventions and things like that. And then finally, based on all of this, you then have your drawings, of course, in which you explain how things are. There are some examples that I've put up over here, and you can see that process as well. There's a case study of the toy ball and the double pipe. So when you see these in the PowerPoint presentations, you'll sort of understand how that goes. And of course, finally are the claims, the most important. The claims are, I claim this, I claim this, I claim this, I claim this. All right. So it could be, I claim a device that is like this. You see, it's got ink. It works with ink, and it works with gravity, and so it comprises of different components. And the main thing is the ink refill, and it is this ink which becomes dry very fast as soon as it is put on paper. It has a ball point over here, so when I press the ball point, the ball goes up and the ink leaks out. So all of these things are what you can then describe, and so you are then claiming these things. And of course, if you claim it, then this is how it would be. You could also say that if you put a compressor pump over here on top, then it can be compressed. Why would that be helpful? Well, then I could use this pen in a situation where there's no gravity. Yeah, you see, gravity is what pushes the ink down, but if I have a compressor device on top over here, which is artificially pushing the ink down, applying pressure to it, then if I am in a spaceship in space, I can still write and the pen will work, right? Because the pen needs ink to come down, and without gravity, the ink won't come down by itself. It may go up or somewhere. But if I have a compressor which applies pressure, then you see all of this is described, of course. And based on the descriptions, you now have your claims. And so you have these claims, 1, 2, 3, 4, 5, whatever. And there are some examples over here, the WIPO patent drafting manual, which sort of outlines how these things work. Of course, this is not from the exam point of view, because you'll go mad if you have to study all of this. But this is just there for you to know. Again, very simple things. So the articles are there, the European Patent Convention articles, then the relevant rules are there, and they are all outlined, and you can read these to sort of understand what are the requirements. And there's also this, the outer form, the publication number, everything has a meaning, and of course it all applies in a certain way. And so it's all highly technical and of course administrative, and it has to be done properly. So who are the key people? There's a patent applicant, of course. So you apply, and then there is the patent examiner. Now this examiner is the expert, and her or his job is to look at your patent application and to try to understand what the application is all about, what the invention is all about, and then use her or his knowledge to sort of find online or through their databases or all of these things. So you have their espace.net is this European Union, European Patent Convention database with, I don't know, some 60 million documents on it. Then there's a USPTO, they have their own database. These are all publicly available. And these are state of the art. The examiner would be knowledgeable and would now look up all of this. And of course, it's a complex system, basically they have a classification program also. And so, if it's, let's say it's this thing, so a pen like this, well, the key ingredient would be the ink part. Yeah. So already there are certain areas that would be looked into. One would be whether the dry ink is a chemical compound which has already been applied for and granted as a patent or been used in the past. So if it's not novel, then you can't get it. Another aspect would be the idea that it is influenced by gravity, and so is that something which has already been invented in the context of some other mechanical invention or writing invention or whatever. So they have this entire system. And if you look at the toy ball and the double pipe case studies, I hope you will sort of understand how the process works out. And so this is a person, the patent examiner with a technical background, and then this person will conduct the search and of course, deal with this matter. And then the representative is your professional representative, as in a patent attorney, who will work with the client, which would be the researcher, the scientist, and then they would sort of work together and draft the application and then answer all the questions in the examination process and deal with all the legal issues that arise. And of course, if this matter goes to court, then again you have specialist lawyers who deal with patent matters and things like that. So what's the patent granting procedure? You apply. So you have prepared the patent application. If you see the case studies, you will see what the process is. What are the terminologies that are used? Once the patent application is sort of ready, remember you cannot make amendments or changes after you have filed it. So that's a very important area. So you have to be really very careful about what you think and how you plan it and what you put down in the application. It's not something that can be changed frivolously later on. Your description is what is the basis for your claims. So your claims are derived from a description. If your description is about something else, your claims are about something else, then it's not feasible either. So you have all of these things to be careful about. And the patent attorney who is helping you to draft helping the client to draft the patent application will also conduct an informal search and see whether something similar has already been done or not by somebody else. So you see, in the case studies, both of them, you will see how this process works. And then the applicant files the form along with the patent specification, and this is now filed and you pay your fees. And within 12 months, you can then apply and say that you want to carry out a search. So again, it's very modular, all right? You say that you want to conduct a search, pay a bit more, and now a search will be conducted. And this is a preliminary examination, and the patent office will say, like in the case studies, that yes, this is similar to something done in the past. Please explain how can you get a patent for this. And you could make some modifications. You can't add anything, but you can always subtract things. And once all of this is done, then of course there will be a detailed investigation. And then based on this, the patent office will then publish the patent application. And now it comes completely into the public domain. And whoever wants to oppose now has time to oppose it. And after this stage, you can, as an applicant, then still, if you feel that you want to continue, you can pay a bit more, some extra fees, and then there's a substantive examination carried out. And based on the examination, you are then told that, look, these are the problem areas, deal with them. And if you can, then you get the patent. If you cannot, then the patent is not possible. And so you try to meet all the requirements as in the case studies, and then maybe you have to cut out some parts. You can't add something new. And so you have to think and plan out carefully how you want your patent application to be. All right. If it's too wide, it's too wide. Then it's a problem. If it's too narrow, then it's again a problem. So, like for example, in the toy ball, you say you shouldn't ask for a toy ball. Yeah, because then a ball is spherical in shape, and that would mean that your competitor, even if you get a patent, your competitor could make something which is not spherical but oval. Yeah, and then you see it's still a toy, it's still a ball, but it's not spherical anymore. Another thing could be, instead of calling it a toy, you should call it an amusement device. You see, there are all these things that you have to be very careful about. And if you see the case study, you will sort of understand what are the limitations that you have to be careful about. It's how you draft it. This is very important. Technically, everything has to be correct, but legally also it has to be done in the right way. And so the application procedure is you file it, it's examined, there's a search report, then it is published, then there's a substantive examination, then either the patent is granted or not. And then once it's done, then you are told, okay, congratulations, you have a patent. And now it's for 20 years from date of application. The whole process may have taken 2 years, 3 years or something. And now you still have some time left, lots of time actually, 15 years. And now you have to decide whether you want to continue to have the patent for just 5 years or 10 years or full term, and pay extra every time for every year. And that's because you see, very often what happens is your invention is obsolete even before it is introduced into the market. Yeah, I mean that's the tragedy of sorts. So again, you have to be very money minded about these things. And well, after the patent has been granted, there is the process for opposition. Then there's a process for revocation. You don't want to keep the patent. Then there is a renewal fees which have to be paid. And then there can also be invalidity proceedings in the court of law. So you have all of these issues. So what are the rights of a patentee? Well, you have rights to prevent third parties from misusing your invention or your patent without giving any money to you or without taking your permission. And so there are these rights which are confirmed. You have exclusive rights, and you have a monopoly. And of course, I have also spoken a bit about some of the problem areas that can arise over here. So well, we'll spend some time on this and look at this more carefully in the next lecture. And I'll try to wrap up and just talk a bit. Don't want to rush into it today. And then I'll also talk a bit about designs. So let's stop here for today. And let's continue again next time and deal with this in more detail. So for today, you have to read the notes that I have spoken about. Of course, view the lecture and check the two Dabus decisions, and that should suffice for today. And then that should keep you occupied. All right. So until next time, thank you and see you next week. Goodbye.